Hello, my name is Antoinette Bone, and I'm an estate planning and elder law attorney here in the Dallas-Fort Worth metroplex. And today I'm going to discuss the pre-need declaration of guardian. So what is a pre-need declaration of guardian? Well, one of the most important reasons to engage in comprehensive disability planning is to have a plan that addresses who is going to be in charge if a court determines that you lack the capacity to take care of your physical well-being as well as manage your personal business affairs. Now, there's one document that specifically addresses this issue, and that is the pre-need declaration of guardian. The Declaration of Guardian allows you to name someone who will serve as your guardian if the need should ever arise. While having a durable power of attorney is a must for even a basic estate plan, you should think of the Declaration of Guardian as its companion who steps in if the power of attorney should fail. Now, why might a power of attorney fail? Well, I'm glad you asked. As previously stated, a power of attorney is a necessary part of even a basic estate plan. However, the biggest fallacy of a power of attorney, whether it is well drafted or poorly drafted, because not all powers of attorney are created equal, is that the law does not require they be accepted. Now, in the normal course of business, they will be, but there may come a time when an entity will refuse to accept the authority granted to the agent in the document. This is most commonly seen when dealing with financial institutions. In this new age of rampant elder financial exploitation, powers of attorney are scrutinized much more. Since financial institutions have a great deal of exposure for allowing someone to access one of their clients' accounts, they can be extremely wary. Now, there may come a point in time where the bank or another entity wants to deal with a guardian instead of an agent, because a guardian has been appointed by a court and has to answer to a judge to explain their actions. Now, in Texas, we have two types of guardians. Someone who has been appointed to handle your financial matters is called a guardian of the estate. And someone appointed to make personal and medical decisions is called a guardian of the person. One person may fill both roles, or different people may serve in each role. The court is obliged to appoint the person you name to serve as your guardian unless the court finds them unsuitable for specific reasons set forth in the Estates Code. The person you have named has priority in being appointed, and the court is obliged to not appoint the person or persons you identify as someone you would not want to serve. Why disqualify someone? The Declaration of Guardian allows you to name who you want to serve as your respective guardian. As important as it is to name someone who will serve as your guardian, it can be more important to identify who you would never want to serve. If you do not have a harmonious family, it can be extremely important to disqualify certain family members from serving. Disqualifying someone can keep them from meddling in your personal affairs. If you have a current or ex-boyfriend or girlfriend, keep in mind there might be a possibility that the ex might assert a common law marriage claim so that they become entitled to serve as your guardian. So who should you appoint? Clients generally appoint the same person in the Declaration of Guardian that they have appointed in their powers of attorney. So the people named in the statutory durable power of attorney serve as guardians of the estate, whereas the people or persons named in the medical power of attorney serve as guardians of the person. I'm Antoinette Bone, estate planning and elder law attorney in the Dallas-Fort Worth metroplex, and I thank you for listening, and I will see you next time.